Hello, everyone. Thank you for joining us today for another trust education webinar. My name is Kurt Kohler, and I'm a trust consultant here at National Advisors Trust Company. Today's presentation is titled Choosing the Right Trustee and is presented by the Executive Vice President and Director of Personal Trust for Cannon Financial Institute, Daniel Smith. During the presentation today, please feel free to submit any questions you have via the chat box. You can simply click on the icon at the bottom of this meeting window that says chat, and the chat box will pop up on the right side of your screen. Daniel will address any questions you have as you submit them. Please also make sure that your line is muted during the presentation. You can find this function on the bottom left-hand side of your Zoom window. A final note before we begin. Following the webinar, you will receive an email that will instruct you on how to file your CE credits for attending today's Trust Education webinar. That email will also include a PDF of today's presentation slides. So again, thank you for joining today. I hope you enjoyed the presentation. And with that, I will now hand it over to Daniel.
Thank you, Kurt. Glad to be with you again. Today's program is on choosing the right trustee. And that sounds very judgmental, but it's not meant to be at all. It's the right trustee for the client and the situation that they happen to be in. That might be an individual trustee, it might be a professional trustee, it might be a corporate trustee. It's a matter of making sure that people are thoughtful about what they're doing. Interestingly enough, while a lot of thought and effort seems to go into the creation of the estate plan, really thinking about what the components are and who you want money to go to, I don't find that a lot of thought conversation is put into the choice of the trustee. And I think that's an unfortunate situation. It's maybe a little bit harder conversation for some people to have because like a lot of things in family dynamics and such, it's a soft skills conversation. It's really about thinking about the technical aspects of it. And I don't mean the tax components that go along with that. There are a lot of those. One of the articles that I cited spends most of its time going into the tax traps that can occur when you have a related trustee serving in the arrangement. And so we just want to look at this from a global perspective and say, how does one go about making that choice and what is the formality in it? So the description of the session we're going through today is just selecting the right executor, trustee. Same kind of things go into any other documents the person might have, powers of attorney, et cetera, making a thoughtful choice about what to do, both the time and timing, what you're doing, the roles and responsibilities, communication, relationships, conflicts of interest, all the other elements that go into that process. And as we go through, again, for particular clients that jump to mind, sometimes these things can be used as a conversation restarter with somebody that you want to reach out to or somebody you've had this conversation with in the past, make sure they're following up. Just make a note of those things so that we can do something with it. But I thought this was a very well put quote in this one article, 52 questions to ask before choosing your executor and trustee. It said, serving as an executor trustee is neither an honor nor a game for beginners to play. Acting as an executor trustee requires technical skills, experience, and an ability to deal with the family members involved. Nevertheless, clients often choose an executor trustee without fairly evaluating the needs of the estate or trust against the named fiduciary's abilities to meet those needs. So there really is, I mean, obviously I run the largest trust school in the United States, so I'm very familiar with a lot of the technical skills and expertise and the communication skills involved in the process of laying this stuff out. But a lot of people rely immediately on family members. I've heard the statistic, I've never seen the exact backup for it, that about 75% of the time individuals are named in documents. It just gives you an idea of the prevalence of that. I can't, again, speak to whether that's right or wrong because I haven't had conversations with all those people as you're going through. So it is important to have the conversation and make sure that people are thinking about and have a framework for looking at why we name whoever we would name as a trustee. Keep in mind that being a trustee or executor, I'll use trustee as our primary driver in here because trusts are sort of the estate planning tool of choice, especially the wealthier clients that people deal with, but the same concepts act in any fiduciary capacity that somebody might have. So, clearly you don't have to be licensed to do this job. Any individual can do it. Spouses, children, friends are named all the time in people's documents, whether that's a good idea or not. It really has to do with their individual situation. So you hear about individuals and you hear about corporate trustees, the other end of the spectrum, right? So NATC acting as a corporate trust company. This is the licensing for that is typically through the banking regulations. And so there's a lot of banks, independent trust companies, brokerage firms, mutual fund companies have now gotten into this side of the money management and financial management process. And in between that, I think it's fair to say that there's another class of potential individuals who can act in that way, and that are professionals in the business, somehow related to the business, attorneys or CPAs or other people like that. There's oftentimes a reluctance by those people to operate in this space just because of the liability and the time sometimes required of that. It's just a different area of practice, but I've seen more of that around some of the down economic times and also the down economic times in estate planning in general, because as the estate tax exemption rose way up, there are a lot of attorneys and people who looked at what they were doing. Sort of the mom and pop estate planning stuff went away when everybody was affected by estate tax at 600,000. It was a pretty easy thing to get people interested in. Everybody needs to do estate planning. No changes have taken place there, but I think it's fair to say that the complex stuff where you're actually doing tax planning associated with that relates to so few people that a lot of people in some of these estate planning team professions looked for additional ways to supplement their work and what they do. Elder law is a natural area of this, and we talk a lot about that in these classes, all of the related elements of the profession that go into the areas that include estate planning. And so acting in that role is one of the ways that you can operate. It's easier for a big firm to operate in that capacity, because if you really are getting named in a document, and that's going to be downstream, right? It's a long-term business for us. As a financial advisor, for instance, I recommend talking to people about that and setting up so that they can have their estate plan properly managed on the back end. But it's going to be a long time because most clients act as their own trustee initially. And so it's not until a client becomes incapacitated or passes away that the successor trustee actually steps into that role. You can name them sooner than that. I think a lot of cases it's a good idea to do, but it usually is a downstream process, and you start seeing about a 10-year build going into that, from my experience, before then clients start passing away and that starts turning into business, what we call future fee business as opposed to current fee business. And it's very important to keep both of those plates spinning, as it were, because it's not just about acting right now. That is an area where sometimes you'll see attorneys step into that role. Somebody passes away, it's brought to their attention, and so it's an immediate issue. Maybe a family member is willing to turn it over to somebody, to a professional in the area. So there's no specific licensing that is required. Obviously, people who are in the corporate trustee businesses are licensed and follow very specific protocols and regulations and those kinds of things. Generally, independent professionals are just operating under their professional licenses, and of course, individuals have none of the same. And so that's what where that quote sort of talks about it. And this is just a legal identification of the fact that individuals can serve, because it sometimes surprises people that just anybody can act as an executor, act as a trustee. So it says individuals have the legal capacity to serve as trustee if they are competent and of legal age. That's all that's required to operate in these roles, right? There doesn't have to be any experience or knowledge or anything else, which is a little scary if you think about it, when you're talking about my entire life savings and for the most important people in the world to me. So it goes on to say that someone who's also a beneficiary or a settlor may generally serve as the trustee, right? We know in revocable living trusts, for instance, very, very often they're set up as self-settled trusts where I continue to be the trustee on my own trust for me as a beneficiary, right? And it's just evidence right there. In general, in irrevocable trusts, that can become problematic from a tax standpoint. There are lots of issues that come up if I'm trying to give away the money, but during life, that's okay. So there may be tax reasons against such appointment, but there's typically no legal constraint to a person serving in more than one role. That means that my spouse could serve as the trustee of the marital trust, of the credit shelter trust. My child could serve as trustee of a trust of which they are a beneficiary. Again, there may be tax and other legal issues that come into that, but from a functional standpoint, those things are generally taken care of by the estate planner themselves, by the attorney, to make sure that they're not crossing any inappropriate lines in the process of doing that. But really thinking about the functional aspects of the role, it's really important to think about the things that a trustee actually has to do. And so having some kind of a reference piece for this, and if this helps you along those lines, please feel free to use any elements of these materials. As you said, they'd be distributed after the call. You are welcome to take this information and lay that out. We've summarized this in previous sessions where we've talked about in great detail what a trustee does. But let's just kind of recap some of those things, because from a functional standpoint, if you're looking at the depth of that role, number one, you have to decide whether you're going to accept the role in the first place. Even corporate trustees do this. Is why it's very important, I think, in the planning process to make sure that the trustee, whoever they are, individual or corporate trustee, is involved in that process to ensure, even from their perspective, that they're the right person to do it. It's shocking, I think, a lot of times that family members who are named as trustees don't want to act in that role, and were either never informed of that fact that they were put in that position, or they are afraid to tell the parent, perhaps who's naming them, that they don't want to fulfill that role. I've had many of those conversations. You can imagine I work with trustees all the time. And if my job is to settle estates and manage trusts all day, my parents might well think that I'm very capable of doing that. There's some very good reasons not to do that, but I've run into many trust officers who are not interested in doing that for the family, again, for many of the reasons that we'll talk about that have to do a lot with family dynamics. But the first thing really is just accepting that role, trying to determine, am I the right person for this? Am I properly able to serve under the terms in the document, right? We obviously have to read and understand the document, what it's calling for us to do, how long it's going to go for, that it's legally drafted, all that kind of stuff, and really just ascertain the purpose. What is the key driver inside of this arrangement? And do I feel comfortable that I can carry those things out? But then there's a lot of logistical work that has to be done. And this can be very, very time consuming, and it is very detailed in its nature. One is to inventory the assets, right? You got to safe keep all the assets. You got to value all the assets. You have to get a list of every single thing that that person owns or controls. And most of us don't keep very good lists of those things. And so it is important to realize that you have to find everything that I own or control and be responsible for that stuff. And you're legally responsible for each of these elements. Obviously, there's an ongoing communication part with the beneficiaries. And so again, if they're family members and friends of mine, those are things that will sometimes be problematic for people. Clear communication, open communication, very, very important. Where I found abusive situations where individual trustees have been doing things wrong. Even in one recent case I was working on where a professional trustee was doing things massively wrong. The thing that tipped me off in that particular case was an inquiry from a student, and they were talking about a family trust that they had. And so I said, well, get a copy of the trust agreement and the latest statements. And they said, well, we asked for that. And they said we couldn't have that. Well, that's an immediate red flag, right? Because a professional should know what the rules are in the area. And so clearly that just is an indicator to me that they're trying to hide something or cover something up, because of course the beneficiaries have rights to the information about the trust because they're the beneficiaries of the trust. And how could they enforce it? How could they make sure that those things were done properly if they don't have the ability to communicate? And by way of communication, by the way, if you want to ask questions, not just about things that you wonder about, but that are questions that get posed to you from clients, we can talk about different ways to be able to address some of those things, right? A big part of our job is just communicating stuff like this with our client base. So communication, very, very important as you go through the process, keeping a transparency associated with what is going on. And of course, there's a huge job inside of this of the investment management, investing the funds themselves. This is where we get called, if your primary role is as a financial advisor, why it becomes such an important part of every conversation that we have to make sure that clients have these funds in place. They usually want to keep you involved downstream. And so because of that, if you're helping them comprehensively and talking to them about all the things that surround their investment portfolio, obviously my concern for clients when I was in that position was that should the client become incapacitated, I wouldn't have the ability to make decisions on their behalf. And so I need to know what their estate plan looks like to identify who else would I be communicating with, and have they communicated with them that I'm the advisor, and that they, that I know the rules by which they'd want to follow in that investment management on an ongoing basis. So very, very important to consider that. And many times you'll get called upon by them. Could you serve as my trustee, right? A very common thing that happens when we're having those conversations with people. The attorneys get drawn in the same way. Would you act as my executor or trustee? And again, it's a professional decision as to whether they choose to do those kinds of things or not. But naturally, if you're the one at the center of that conversation, you're a trusted advisor on their team, they sometimes reach out to you for that. And by the way, our answer on that, I'd suggest not saying no, which is sort of the legal answer that's associated with that, but rather to say, sure, I'd be happy to, or here's how I do that in my practice, right? I have a National Advisor Trust Company, and they serve as the corporate trustee. They're the one that gets named in that process, and I stay on with the family, acting as the investment advisor and a liaison for communication with the family. That's usually the part of it they're really looking for in the process. And so by starting out with a yes, and here's how I do it, rather than no, that's really more the answer that the client's looking for, right? What you're really doing is just changing their perception. They don't really know everything about what's involved in being a trustee and why those pieces are segregated. And so it's really important to help people to understand and sort of divide those powers. What they're really asking is, number one, they're complimenting you because they want to keep you involved. They're as a trusted advisor within the family. But what they're really asking is, I want you to continue to be involved should this happen. And so it's a really important thing to examine with the clients. And then, of course, there's the distribution of funds. In some situations, that's very straightforward. It's just an automatic distribution. In estate settlement, for instance, it might just be equal distribution among the kids or something along those lines. But now, again, you're going back to the inventory of the assets and breaking things up and trying to find fair ways to do that, because there's only so many people who can get the grandpa's ukulele. So from a functional standpoint, it's really important to understand that that's also where some of these issues come along the way. And in trust, for instance, over a long period of time, you can have a discretionary distribution stream that is paid out. And again, that's where the conversations back and forth, saying no to my siblings or to cousins or whoever within the family, those kinds of things can come up. There's lots of tax returns. We've certainly talked about a lot of those things over the years as we've done these courses. So for gift, estate, generation skipping, transfer tax, all the transfer tax returns that go in, as well as income tax returns and anything else to be associated with that. Again, it's where CPAs so often get involved or outsource those parts of the job. People specialize in those unique areas of even the tax law that we operate in. So you can delegate duties to anybody who needs to be there. So if I'm an individual and I don't have expertise in that area, I can hire other people, attorneys and CPAs, to assist me. Even if they're not willing to act in that role, they can do parts of that job on my behalf, which is also why when you look at that list of things and say, well, I can get this person to do this, I can get this person to do this, I can get this person to do this, you realize that an executor or trustee who is free because they're a family member usually does not end up being free, and in fact can be more expensive than even using a corporate trustee or professional trustee in the first place, simply because if you're set up in the business to do those things, you have all of those capabilities on board. There's an economies of scale that is driven with that, as opposed to an individual who's going out and hiring all these individuals to do this stuff. It's sort of like buying things at retail as opposed to delivering it at wholesale, because that's the business that you're already in. Very, very important element. So you can delegate duties to other individuals. You can hire outside help as much as you want to assist you in doing the job. The courts want to make sure that the job gets done right, and they're very happy to have that done. And obviously the loyalty is the primary thing. Again, conflicts of interest can come in here. If I'm a beneficiary trustee, obviously I need to treat all of the beneficiaries in an appropriately fair way, right, according to the documents, and yet I naturally have a tendency to be biased to myself. And of course, come to the eventual time when you would terminate the trust. And again, things like that don't seem like they would be controversial at all or questionable, but I ran across one where they had basically just agreed among themselves because they liked the arrangement to continue a trust. At the point that I got into it, it was about 13 years after the trust had actually terminated. They'd never created a new structure. They just thought it was working well in the way that they did it, and they kept operating it in that way, even though the trust did not exist anymore. It's just very strange situations that you run across occasionally that help you understand. It's nice to know what you're doing. Nothing wrong with thinking a trust is a great thing, but if the trust is terminated, you need to terminate that trust and create something else. You can create a new arrangement, you create a new trust, and have that state whatever it is you want it to do. So some of the trustee attributes that I found in one of these articles I thought were very well put. I tried to source all of this stuff, so it wasn't just my opinions and things thrown out there, but they're coming from learned individuals in the business with very nicely worded ways of doing that. But there's a lot of personal attributes. I didn't focus here so much on the tax stuff because, again, you should be working with a knowledgeable attorney who's a specialist in the area of estate planning, and they should be able to make sure that those parts of the document are appropriately addressed when they are using individual trustees. But I was more interested in the sort of the personal attributes to be considered in selecting a trustee. So clearly, sound judgment is one of those things. There are many, many cases where we have to make decisions about things. What is the best way to do something? What is the right way to do something? It needs to be ethically inclined. So that honesty and integrity are critical parts of this, as well as having key elements of responsibility. But also that they can be impartial, right? Or desired partiality towards the decedent's preferred beneficiaries. So it's nothing wrong with a trust saying that my surviving spouse, for instance, is the preferred beneficiary of the trust, and the needs of anybody else shall be put aside, in effect, right? In other words, take care of my surviving spouse. Anything they need, basically, they get. And if there's anything left over, then it would go to these other beneficiaries over here. So you can clearly be preferential in the way that documents are created. So it's very important to understand, again, the purpose, as I said earlier, is a critical part of that. And being able to grasp that purpose, to really understand what that intent is. Again, this is why there should be a conversation during that person's lifetime with the person who's going to step into that role, or the firm that's going to step into that role. Having a developed relationship and an ongoing relationship is critically important. Again, this is where it often connects through people like the financial advisor who are involved in that person's lifetime. They understand how that person thinks, the way that they do things, how they spend money, why they do what they do with their money. There are some people, you can look at their balance sheets and see 10 different people will do 10 completely different things just based on the way that they view stuff. So financial investment sophistication is an important part of that process. And it is critically important to do that not in my risk tolerance as the executor trustee, but in the scope of, in the context of the trust that I'm serving in the process of doing that. Other attributes desired would obviously be locality. In fact, in some places, you can't act as an executor unless you do live locally. A lot of that has changed because technology allows us to reach over longer periods of time. But you can imagine, I was in the business in Hawaii, which is where I grew up, and we had that rule for a long time that you had to be a resident of the state of Hawaii. After all, even if you're in California, the closest possible state we could have, that's thousands of miles and thousands of dollars really to be going back and forth on a regular basis to be able to do a job. Even just an estate settlement period usually takes about a 2-year period of time. You can imagine a trust that's in an ongoing state. That is a huge, huge investment of time. So that locality for trust, for tax law, for beneficiary convenience, for even communication, those kinds of things, it can be really, really useful. Secondly, permanence. When I name an individual, I'm always at risk of that individual not being capable of continuing on in that role. They might become incapacitated. They might get too busy doing other things. They might pass away. And so it's very important that I make sure that permanence is there. It's one of the things that I love about corporate trustees is I know that corporate trustee permanence will always be in place. And then continuity, which is really important for long-term trusts, and more, just because the nature of trust planning and some of the elements of taxation that have gone away for the typical person, long-term trusts really provide great benefits for people. And so again, I know if I'm using, for instance, a corporate trustee, that if Daniel is my trust officer, Daniel will eventually retire, go crazy, or pass away, and somebody will simply step into his shoes. And I have this continuity of practice and of records and all the things that we need to have inside of that trust to make sure that those things continue to be done properly, generation after generation. I also see situations where people will use family members, especially when there's a family business involved, something like that, along with a corporate co-trustee where they'll be operating with other people as well. So again, there's no right decision for any one person. You have to figure out what it is for your own situation and how that works. But again, loyalty, trustworthiness, experience as a trustee certainly has to be considered in that area. This is a job that when put upon a family member is usually the first time that they've ever had to do it. I have found in counseling people in situations like that, they often have no idea even what is asked of them to do in a situation like that. So these are also situations where very often if an individual is named, that individual can bring in a professional instead. So if I'm named in my mother's will or trust as the executor or trustee, and I'm to step in when she becomes capacitated or passes away, and that's a role that I'm unfamiliar with, and I might be talking about that with you as my advisor, legal advisor, tax advisor, financial advisor, whatever role you happen to play in their life, it's really important to understand to say, well, if you don't want to do that, you could turn down that role and nominate a professional trustee or a corporate trustee to step in and act in that way. This is very important because sometimes people take on the role not fully understanding what is they're responsible for, and then they get into trouble, right? They've done something wrong already, and now they have kind of a problem. And in fact, handing it off at that point might be a problem because nobody wants to step into a already existing mess. So you want to avoid those conflict situations that result in certain family tensions and hostilities, might lead to lawsuits. Those are expensive and time consuming, and is frankly a reason why we often did not accept successor trustee business in certain circumstances. You certainly have to do your homework and make sure that you understand a little bit about the history of it. And it's very often what I would find is somebody has messed something up. Now they're trying to hand it off to the professionals. Well, the professional doesn't want to step into an already brewing lawsuit that's coming. So it's a very difficult thing. So it's very important that people understand this in advance, that you want to fix it and do it right from the beginning so that you can have professionals who will operate in that stead. You also want to know how the trustee will react, right? When you're faced with various kinds of choices that favor him at the expense of others, right? So I'm really making sure that I've got my ethical hat on properly. What are the intrafamily implications of those choices? This is particularly important, certainly when you have some kind of a mixed family situation, when you have second marriages, you have kids from multiple marriages, those kinds of things. This is where tensions can run higher. And so it's really, really important to understand the elements of family dynamics and the way that those play out. So for instance, would a person alienate one family member, denying a distribution, or ingratiate himself to another by being liberal in his policy of making distributions? Both of those things can be a problem on both sides. Oh, I'll just be really nice so that everybody will like me, but I'm violating the terms of the trust and the purpose of the trust in the process of doing that. Or I'm following strictly the terms of the trust, and now people get mad at me because I'm not giving the money just because they want it or don't understand what's going on. And if I don't, even if I legally understand the trust and what is necessary to be carried out, if I've never done this before, I might not be good at communicating that with the beneficiaries who might know nothing about the trust and simply want to terminate it. I've been in the middle of family conversations about that kind of stuff too, where people just go, can't we just make the trust go away? I said, no, it's your parents' trust. It's an arrangement that they created. But again, I've seen situations where they've named children into that role and the children did not follow the terms of the trust. They simply violated every bit of it because frankly, if all the beneficiaries get together and say, why don't we just distribute all the money to ourselves? That's essentially what they did, which is not what the parents wanted. So their entire estate plan basically failed because the person that they named as the trustee was not in a position to carry those things out. So that's what we mean by how the trustee will react once they're put into that situation. It's a difficult thing to simulate, to have an idea in advance. It's one of the reasons why a lot of people who have family businesses, for instance, will put their kids on the board or give them positions of power, because they want to see how they will operate within the business structure, even to figure out which children they think should run the enterprise afterwards, who will really dedicate the time and attention to it, who make good judgment calls when there are tough situations on the line. So very important elements of that process. And of course, creating bad blood within the family just never seems to get repaired along the way. Lots of people who will never speak to each other again because of things that were done in the settlement of an estate that, whether correct or not, right? Understand, I can do things absolutely correctly, but if they're misunderstood by the others, then I may not be spoken to. I've had kids bring their parents to me. I was doing a thing in business succession one time, and I remember this son and father walked up, involved in family business together. The son was the father's chosen successor within the family business, and the son was very, very concerned about being put in that position, because he said, "I know everybody will just attack me in what I'm doing." And so we had to work through some of the family dynamics that goes along with that. So family dynamics is a really, really important part of the process, understanding not just that the person is capable of doing the job, but that they are willing to operate in the context of the family when making those decisions. It's a very, very challenging place to be. And one of the nice things about having a neutral trustee is that they can sit on the side and make those decisions. And you can get mad at me if you want to. It's my job to help communicate why we're doing what we're doing. And so hopefully you help people to understand that, whether they like it or not, doesn't matter. It wasn't their money and they didn't create the arrangement in the first place. So at least you have a neutral arbiter who can make those decisions. Going on, will the trustee be subject to influence, right? Will the trustee, such as a grantor spouse, be subject to the influence of one or more children, or a second spouse, or a lover, or somebody else who comes into their life after my death? Let's say I create a trust for my surviving spouse, and she meets somebody else and gets married again, or just is with somebody, or maybe being taken advantage of by somebody. We talked about some of this in the elder abuse sections that we have. So very, very important to make sure that we're not making distributions that may or may not be in the best interest of the other beneficiaries. Is the family member trustee easily persuaded or likely to show favoritism to one party or another? Very, very important. And then, of course, the remarriage of a spouse or a child who's named as the trustee may result in less impartial decisions, where the trustee has been given discretionary authority over the trust income or principal, even the new spouse is not included in the class of possible recipients. This is something that a lot of people don't think about, is just that most trusts are created and name by class only blood heirs of that individual, not the spouses and other parties who are involved in this. And I've seen, again, individual situations where in that trust, they're making distributions clearly in favor of the spouse of a child as opposed to the child themselves, which is a violation of the terms of the instrument. These kinds of things have caused the entire thing to blow up, or people to be personally liable and financially liable to the other siblings who were involved in the arrangement. A very, very difficult situation to be in. So it's usually individuals, again, it's just a lack of understanding what people have. They usually have great rationalizations for it, but it's not right. I mean, just quite simply is a breach of trust. And so it's a challenging thing to think about, because when these things are downstream, it's like, what could happen in the future that might also affect this, right? People have great faith in their children's ability to carry things out, but the children simply have a conflict in those situations, right? I think I've talked before about the Lady Astor case, where exactly that happened. She only had one son, and he was certainly a smart man. He was a lawyer by education, at least. And Lady Astor apparently was not terribly fond of his spouse. And when you live off of a family trust and realize that if I die, my spouse is not a beneficiary of that trust, maybe there's a conflict of interest within me to do things about that, and maybe to get more compensation out of the trust, or make more distributions out of the trust so that I can provide for my spouse separately of this. They could manage their continue their same lifestyle should something happen to me, and my spouse would be left out in the cold, in effect, not a beneficiary of the trust anymore, which is providing a substantial part of our income. In that case, he went to jail at age 74, I think, for a long time for messing this stuff up, for just the breach of trust that's arranged in that. You can avoid all that simply by using professional trustees, corporate trustees, people who know what they're doing in the area and are going to make sure, almost to the point of being obnoxious about it, that things are done absolutely correctly. So I thought this was an interesting way to put it. Is out of Stephen Leinberg's Tools and Techniques of Estate Planning. It's a textbook that we use in our Trust 1 class as a trust school in general, but it's given out in the Trust 1 class to kind of talk about the roles of trustees, but also taxation, other elements associated with estate planning. But he said the child trustee may take on the role of a parent to his or her remaining parent or siblings. That can be positive, right? Because you're acting in that great role model capacity, but it may also result in an attempt to control the lives of family members through the family finances as if that person were a parent rather than a child. I never really thought about it in that way, but it's an interesting perspective to place on that. You can certainly understand the conflict of interest and the other kinds of things that come along with that, but it's just that alteration of the relationship because of the job that I've been given. It's kind of a natural thing that you can understand. People might step into that role sometimes a little bit too much. Clearly, Stephen is speaking from experience, I'm sure. An independent professional trustee is not subject to this problem, since the choice between no and yes may be one of the most important duties of a trustee. This ability of a professional trustee to be objective and impartial should be given the highest preference in the decision-making process. Again, this is a guy who has spent his life in the estate planning business, been around it, had clientele, had active businesses in the areas, and now does a lot of writing and consulting in the business. And so to go to people outside of ourselves to make sure that I'm not being biased because I grew up in this business, because I operate in this business, because I do training in this side of the business, and really make sure you're talking about people who have to make those decisions and help their clients make those decisions as one of the key elements of that process. I had a number of attorneys that I worked with who leaned directly towards using a corporate trustee, would tell their clients that directly. My suggestion is that you use a corporate trustee, and here are the reasons why. In Bogart, which is a legal premise, where there is a trust of substantial size, administration of the trust may require special confidence and expertise beyond the ability of an individual or a relative or friend or business colleague. This is for reasons the corporate trustee is often selected. So again, looking at the nature of what we do, we tend to work with the wealthier people in society, and trust companies often have minimums as a result of that. There's a lot of work and infrastructure that is necessary for that. And so there's certain minimum sizes that they'll even operate within those places, within trusts, because of the automatic cost structure necessary to deliver a high-end service within their clientele. So taxes, skills, continuity, some of the other areas, use corporate trustee as an independent trustee, which is an important phrase in some of the tax sections of the code. It allows you sometimes to be even looser with language because an independent trustee is not considered to be conflicted inside of there. You won't have the trust includable in their estate for estate tax purposes. Lawyers have to be very careful with some of the wording that they use when they use individuals who are not independent of the arrangement. So for instance, if I name my spouse as trustee, I'd have to have much stricter language inside of the document as to what discretionary distributions could be made for it. Another reason why a lot of people think using a corporate trustee actually is more generous to the beneficiaries, because you can keep much broader perspective. And for a long-term trust, understanding the way that we describe things today, if I have a trust that might be around in 100 years, for instance, a couple generations downstream, that having a trust that says, as the trustee deems appropriate, might be more appropriate than health, education, board of maintenance, or some other kind of wording that we get in order to avoid adverse federal income tax problems or estate tax consequences. Corporate trustees presumably also bring special skills and expertise to the table, very important for investment and tax and administration. It would just amplify its commissions. And continuity is assured since trusteeship would be unaffected by disability, death, or other contingencies of a corporate trustee's perpetual existence. With regard to compensation, he said, although an individual trustee might be willing to serve without compensation, the savings might be offset by the need to retain and compensate attorneys, accountants, investment advisors, other agents that would be involved in the process. Most corporate trustees involve in their services the delivery of the investment management part of it. That's why independent trust companies like National Advisors Trust Company works with financial advisors in order to provide that investment component of that. All those pieces exist regardless, but we need that custodial record keeping element to the process. We need the reading the document, interpreting the document, making the distributions, communicating appropriately with the beneficiaries component of the process, as well as that investment management component of the process. And you can bifurcate and trifurcate those roles. One of the key things that goes into that process. And you just like a regular corporate trustee would have all of those bundled into one pricing structure that they deliver. It can also be done by having an independent trustee who provides the administrative aspects of that and the custodial aspects of that, and a separate advisor who is handling the investment management aspects of that. So the compensation is broken up between all those independent parties. And while we did use attorneys on occasion as a trust company, we had internal counsel, number one, that we would go to first, and it's very knowledgeable staff who had the ability to do this. Really good estate planning attorneys are doing an interesting thing. When you think about it from a business standpoint, they're in effect taking themselves out of the loop when they use a corporate trustee, because usually the corporate trustee is going to be able to handle things. Naturally, you go back to the drafting attorney when you do that, but there were certainly a few attorneys that I ran into who tended to avoid the use of trust because they knew that they would be more needed if there was more chaos. If there were family members who didn't know what they were doing, they would be more needed in that process of doing things. That's even from one of my students, one of the ways that Harvard taught that at one point. He'd gone through the Harvard Law School stuff, and he said, my third-year professor who talked about will said, gentlemen, no matter what area of law you go into, you need to write a will for all your customers, because that way you can retire into a probate practice, right? That was sort of his selling case for the entire thing. Of course, not terribly good advice by itself. Concept, not bad. I understand it, but it's a little scary. So in split family situations, as I said, we want to look at where the current beneficiary is a step parent of the trust and passes to first marriage children. These kinds of things can cause real conflicts. There's some that are quite obvious that even if there's not a conflict on the surface between these parties, they clearly have different relationships in many ways. And so when money becomes a factor within those relationships, that sometimes becomes problematic. And add to that the fact that there is grief, that there's somebody has passed, there's been harm taking place, maybe that second spouse now goes on and finds another spouse or has kids from a previous marriage, right? You see all these kinds of tensions that can come up. So honor facts, the first thing the estate planner should do is convince the client to use the services of a truly independent trustee. Again, this is from creating an amicable estate plan for the decedent's children and their second spouse. Use of an independent trustee, perhaps corporate fiduciary, removes the opinions, the underlying distrust, the misunderstandings, and most of the personalities from the decision-making process. Consequently, there's a better chance of achieving desired cooperation among family members. Again, just having a knowledgeable, neutral arbiter. We have no skin in the game. So that corporate trustee is there simply to carry out the role. They're not a beneficiary of the trust. There's nothing about it that can be inured to our own benefit in the process. Our job is simply to make the right decisions. It's the reason why we go to courts and have a neutral arbiter, the judge, sit up there and listen to both sides and hear what's going on and cast a decision. The judge is not affected by that decision. They're simply carrying out the law. In our case, we're simply carrying out the document, the purpose of the trust as written. So in just looking at kind of comparing and contrasting, and I'll again do three different sections of this: corporate trustee, professional trustees, and individual trustees. Corporate trustees clearly have regulatory oversight, right? They're chartered to act as a trust company by an appropriate regulatory body. Given those powers, they have to have certain capitalization, et cetera, associated with oversight of their duties. In fact, a lot of people don't know, but there's actually two sets of direct regulatory oversight within the trusts, because trust companies are required to have internal audit staffs who independently examine what they're doing, separate from the trust management themselves. Their job is to make sure that we're doing things correctly as we're going through. Audit, compliance, risk management, those can be rolled into single roles, but it's sort of like looking at risks in the area and try to determine how we avoid those things, right? Kind of forward looking. That's our risk management aspect of that. Audit is kind of in the looking at the past and seeing what we've done and have we done those things correctly. Compliance is making sure that we are following the rules as we're going along and doing what we're doing. And then additionally, because you're holding a license from a state or federal organization, they audit you as well. So they can come in from the outside and examine, do essentially what our internal audit staffs do, but from a completely neutral outside standpoint to make sure that holding that license is acceptable. So we have our internal staff who helps us to stay on track. We have our external staff who's there to help us to stay on track. Those people are not our enemies, they're our friends. They're about making sure that the job gets done right. But it's something that a lot of people sometimes don't think about with respect to the way that that job is done. There's, of course, court oversight. Should we end up in court with somebody having complaints about what's going on, the courts are there to, again, neutrally assess, was the job being done correctly? And if I'm a professional in the area and being paid to do this job, and I hold myself out as a professional in the area, naturally, the law is going to hold me to the highest standards that are out there, as opposed to an individual who, even seemingly was doing their best and ended up doing things wrong. It's a little bit harder sometimes for them to hold on to standards. I'm not saying that they don't say that if you've taken that job, you have a responsibility to learn what the job is and to do it correctly. But you can see from rulings over time that clearly the standards are different when you're operating with a professional trustee instead of an individual trustee who's not in that same role. So I talked about the internal oversight of what we're doing, having clearly defined policies and procedures that we carry out for consistent and accurate professional execution. Every trust company has policies and procedures manual that tells them how to do various kinds of actions, so that from the first day I walk in, I should be able to follow the rule book, as it were, and understand what we're supposed to do. And we also do a lot of things by committee to utilize the experience of people over time, and so that no one person is making a decision how to decide on a particular situation that has come up. Certainly, you've got specialists who are dedicated full-time to the task of doing this. It's certainly not the case with family members of people that might be operating in that capacity. And it's permanent and consistent. There's no vacations or capacity or death, because again, it's put off to a corporation, to an organization that is simply staffing to fill the roles that are being carried out in the process of doing that. Contrast that to a professional trustee, where you're operating under your professional license, generally not chartered as a trust company. There are a few places in the country, usually the old port cities, where there are some law firms that also have trust companies associated with them. They usually can't be in the same company, but they are kind of in the same company. But for the most part, people who are operating in that role are just operating their professional licenses, not chartered as a trust company, and therefore not subject to the outside auditing and those kinds of things. Usually they would only be held to task if somebody was complaining about something. Certainly, you're going to be held to high standards due to the fact that you're charging a fee and to your presumed expertise in the area. But if they don't do it a lot, they may not have that consistency of practice, policies and procedures that always get followed in the same way to make sure that things are being done correctly. In virtually all cases where I've seen professionals acting in that role, it's generally only a part of their practice. Sometimes it was in fact, a favor to a client. There's nobody else close by. There's no other family members who might be able to act in a role like that. So it's in effect a part-time job, certainly within their area of expertise. And so as individuals, naturally, you're subject to all of the issues that come up with individuals, vacations, and incapacity and death eventually. And with an individual trustee, of course, you're just acting as an individual. There's no charter, there's no standards, there's no policies and procedures manuals. I've had a few individuals over the years come through our trust schools. They went to trust companies that they were using for various services, outsourcing agency services and that kind of stuff, and just said, how do I learn more about becoming a trustee? But given the number of them that are out there, I'm surprised that we haven't had more over the years. And we don't advertise that marketplace, but certainly there's a lot of individuals who operate in that role. So certainly, even if something goes wrong, I hate to look at it in that way, but the simple fact is things very often go wrong. And sadly, in a lot of the cases that I've been involved in, there's no way really to recoup, because if the individual has wasted the money or done something inappropriate with it and it's gone, there's nothing to gain back, right? They don't have deep pockets, right? They don't have an insurance company or something else standing behind them who's going to make sure that those things get addressed. Generally have no policies and procedures or specific ways of doing things. They're just doing their best in the area, hopefully hiring some professionals to help them out in the process of doing it. Certainly a part-time job at best. They usually have other jobs, or certainly raising families or whatever else is going on in their lives, something I think a lot of people don't think about. And certainly long-term especially, these can be problematic because of vacations, incapacity, death, the need for an ongoing successor arrangement to that. But sort of bringing that down, the consideration that I don't see brought up in most of the articles I see about this that are addressing very, very importantly, I think, the skills and the attributes associated, certainly the knowledge associated with what a trustee is simply to think about the simple fact of when somebody has to act in this role. This is something that if you're having your children or surviving spouse even do it, it's a big job they're doing for free at one of the lowest points of their life. This is really the big driver and the main reason why I've had, for instance, a lot of trust officers tell me, I've been named by my parents as the executor or trustee, and I don't want to do it, right? And so, we'll have that conversation and sort of draw that out. Usually the first thing I ask them is, are you willing to tell them that? Some are and some are not. And then if they're not, then they'll simply be named in that role and realize that I can hand that role off to a professional when the time comes to do it. And so that's just one of the ways that is an out to do that, to make sure that things get done correctly. It is a very difficult time for a lot of people when you are in the family, part of the family, to be going through that. And it affects not only me as the person who's delivering those services, but certainly the emotions embroiled associated with the settlement of the estate, the death of the individual. So the emotional side combined with the money side can be a toxic mix for family dynamics arrangements. So, it's not an issue of competence. As I say, trust officers are somebody's children too. They're just not the person who passed away. So that's where the interrelationship of that, I think, are a lot of times something people don't think about. When I would have this conversation with clients, that's what I would always ask them. Have you, who have you named as successor trustee? And they'll say, oh, my daughter. I say, oh, terrific. Why did you name her? And have you talked to her about that? Oh, no, we haven't. Been just shocking to me how many people have put children in a very, very responsible position like that and not even told the child that they're named in that position. So I think it's very, very important to have that conversation in the same way that as a corporate trustee, I wanted to know my clients during their lifetime. So I was going to be carrying out their wishes in the area. We want to have a relationship with that person during their lifetime so that continuity can be carried forth. It's their purpose, after all, being carried out. It's not just a set of rules that is there. So enabling professional corporate trustees to be truly objective, to follow the client's wishes to the letter. There's no self-interest, there's no conflicted emotions, all the other things that get baked into that process. And so this is just a very short kind of analysis that I did of saying, when would I use a corporate versus an individual trustee? So with a corporate trustee, to avoid burdening the family with a time-consuming complex job at a difficult time, when family members, spouses don't get along, right? Some of the obvious times when those would be there. Sometimes, again, those are not on the surface, but might be underlying what's going on. Certainly when a family has had financial troubles, when you've had kids who've had IRS claims or debtor claims or businesses that haven't worked out, those kinds of things. Again, those kind of things can cause all kinds of problems when I have power over somebody else's money. Certainly when there's multiple marriages, when the trust will last for a long time. Those are kind of the extreme, more obvious cases of that, but certainly times when I would want to lean strongly on the corporate trustee direction, as opposed to individuals. Or, sometimes when it's a family business and that makes up 99% of the value of the estate, maybe I would just want a corporate trustee to help me with custody and some of the record keeping aspects of it, but not be a trustee, because the primary asset is something that the family wants to run and create and operate. Certainly when the assets aren't significant. As I said, most corporate trustees have a cost structure associated with delivering the service such that if there isn't enough money there to do that, then their minimum fee structure, for instance, is just unfair to the trust. And so it's important to know at what levels we operate in those capacities. Certainly, when people are using individuals and they've got a professional network of people, and they'll trial run this, and a lot of decisions that need to be made in advance, where you've got an existing network of professionals in place. Very, very important to have. Or where substantial handholding is required, physical presence of that individual being involved with, for instance, an incapacitated individual visiting somebody in a hospital, long-term Alzheimer's cases, situations like that. But again, I can do that with the individual and separate that role from the trustee and the financial management of the assets themselves. And so very important to think about the different situations that you go into. Certainly, even when an individual is named, a trust company can act as an agent for the trustee. So I've seen a lot of situations where children were named in a capacity as an executor, as a trustee, realized that they needed substantial help in that area. But sometimes for either pride reasons or because their parents named them in that capacity, they wanted to fulfill the role of being the trustee. And so they would name a corporate trustee as the agent for the trustee. Essentially, they would keep the discretionary decision-making powers at the top, but they have a knowledgeable partner who can help them out in the process of fulfilling the duties and doing those things correctly. There's lots of language around that now with the Directed Trust Act that's been put into place. And so whether they call them a trust advisor or protector or director, sometimes you can involve individuals in a non-fiduciary capacity to do certain things within that role. There's very often the need or desire to have family members involved in some way. And sometimes you'll name the family member as an executor under the will and use a corporate trustee for the trust. The trust usually is where the bulk of the financial assets are. The will is generally in cases like that where a lot of the family memorabilia and personal things get dealt with. And so that's another way you can do it, is just to split those roles into a couple of different pieces. So hopefully that's giving you a pretty broad-based ability to take a look at the discussion around and the support for why you choose the trustee that you do, and why leaning towards a corporate trustee, I think, is a very, very positive thing for people to do, almost using that as the default and working your way away from there. Is there a reason why I should not be doing that in these cases? So thank you very much, and we'll leave it open to questions, and I will turn things back over to Kurt.
Thank you very much, Daniel. We will now open up some time to answer any final questions you may have for Daniel. Feel free to submit them in the chat box now if you have not already done so. While we wait for questions, I want to remind everyone that a recording of the presentation today and recordings of all our previous webinars will be available on NATC's YouTube channel. You can expect to see this presentation uploaded there in the next day or so. Also, if you joined late, I want to remind you that following the webinar today, you will receive an email that will instruct you how to report your CE credits for attending, and that email will also include a PDF of today's presentation slides. If this was your first webinar of ours that you attended today, welcome. I hope you enjoyed the webinar and gained value from it. You will receive an email that will ask you to take a survey. If you would please take a minute or two to complete that, we would love to get your continued feedback on these trust education webinars. So again, if any of you have any final questions, feel free to submit them in the chat box now. I thought I see one there, Daniel. Oh, it says
it was just a compliment from Kevin. He said, good job.
There you go. Thanks, Kevin. I don't see any other questions.
Compliments too, as well as
so thanks everyone for joining us today, and please feel free to reach out to Daniel or me with any follow-up questions. Have a great day, and thanks again, Daniel. Take care.